our side.
You keep saying term limits. There are other presidential qualifications in the Constitution: age,
Yes.
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
so you want us to say, I'm wondering why the term limits qualification is important to you.
Because
are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
Of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The same
if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, well, the same if they're not a U.S. citizen for sure. The age is a little more nuanced, because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well, then that would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, so what, adding qualifications to what term limit is your argument based on?
You're changing.
I'm just confused.
Okay. With respect to maybe I'll start with the age example. If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits, because there could be a 34-year-old on the day of the election who turns 35 before inauguration day. What Colorado has done here, what their Supreme Court has done, is similar, because under Section 3, President Trump needs to qualify during the time that he would hold office. And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme Court.
Now I understand. So
now I just a point of clarification so we're all on the same page. When you say term limits, you mean our decision in the term limits case.
Yes, I'm sorry.
The constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term limits.
That would
I'm
be
sorry.
easier for Justice Sotomayor?
Pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified, because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal, that it's not Section 3 that's at issue, but Thornton and others, as to whether Section 3 can be enforced by states against the president?
That would extend to every presidential candidate, not
exactly,
our client.
Not just to yours.
Yes.
Okay, thank you.
Justice Sotomayor?
I have a problem with laws like this that are so broad that they stifle speech just on their face. Meaning, I think that's what the government's been trying to say. If you have a particular type of speech that you want to protect against or promote, it would be one thing to have that kind of law, but we have a company here, Discourse, who's also a direct messaging app. And there's no question that your law covers them, but they tell us that their whole business model is to promote themselves to a particular message and groups of messages. So they're not doing it indiscriminately. You're basically saying to them, if they're out there and they're a common carrier, they can't have this kind of business model.
I mean, two responses, if I may, Your Honor. The first is, as to the particular company, we're only talking about the three largest, maybe more depending on who falls within the 50 million, the largest telecommunications companies on earth. We're not talking everybody else.
Okay.
So, but as to the second point.
You're agreeing with them that basically this law is aimed towards them.
Yes, to the largest. We've never disputed that. But even if you agree with all of that, I disagree with you, but I understand that there's still applications of this law that should be allowed to go into effect. I don't see how they can say that they can kick somebody off for off-platform speech of their grandmother. That can't be, or because they don't like it where you live in Texas. You know, you live in El Paso and not Dallas, so you're not as valuable to the advertisers, so we're going to kick you off. Surely that can't be okay.
Mr. Mitchell, this conversation is totally confusing me because I thought that your argument depended on what the trigger, that the function of the trigger was what the trigger does mechanically inside the weapon. And therefore, whether you have one trigger or two triggers or three triggers or 10 buttons, it doesn't matter. What matters is what the trigger or the triggers do inside the gun. An M6, back in the day when it was possible to fire the standard military issue rifles, M16 from the 1970s on automatic, my understanding is that the military you can't even do that anymore. All you can fire at most is a burst of 3 shots. But there are 2 buttons on the old-time M16. You have to flip there are 3. You have to flip it over from semi-automatic to automatic. That's one button. And then the other button is the pulling of the trigger. But do I misunderstand your argument?
No, you're not misunderstanding it at all. The function of the trigger is what the trigger does to cause the weapon to fire. That's what function of the trigger means. But to determine that, we need to first determine what exactly the trigger is before we can consider what is the function of the trigger. And there will be certain types of devices, like this motorized trigger device in the United States against camp, where the trigger actually is changed because you're no longer pulling the curved metal lever to set off the weapon. Instead, you're flipping some switch that starts a motor.
Now I'm completely lost. The trigger is not doing anything. It's the person doing something. And it's the person choosing on an M16 whether they're going to keep the switch on semi-automatic or put the switch on automatic and turn the M16 into a machine gun. And on a machine gun, it's not the trigger that does this, it's the pressure that the shooter is using to hold the trigger down that permits it to keep going.
That's what causes the trigger to function.
Well, but the pause, that's what the government is saying, which is you're not looking at what the trigger is doing, you're looking at what the shooter is doing, and is he using a force, keeping the gun down, keeping the trigger down, or holding the bump stock and letting it shoot back and forth in an automatic recoil. Those are not things that changes the automatic nature of the firing.
It still has nothing to do with what the shooter does. The question is, what does the trigger do when it functions? And if the trigger allows more than one shot to fire per function of the trigger, what is the single function of the trigger?
But
and on
the trigger you're saying can be a button. So why can't it be the bump stock that's forcing this thing automatically in a recoil motion to go back and forth?
Because the bump stock doesn't fire the weapon. The bump stock is just a case in which the weapon slides back and forth. That doesn't do anything to fire the weapon.
Justice Sotomayor?
Why would even a person with arthritis, why would Congress think they needed to shoot 400 to 700 or 800 rounds of ammunition under any circumstance?
You can't shoot.
If you don't let a person without arthritis do that, why would you permit a person with arthritis to do it?
Well, they don't shoot 400 or 700 rounds because the magazine only goes up to 50. So you're still going to have to change the magazine after every round. We allow large capacity magazines up to 50. And also, there are many shooters who can pull the trigger of a semi-automatic rifle very quickly, who can accomplish rates of fire similar to those that approach fully automatic weapons. So I don't...
Counsel, you spoke about legislative history, and I think you're trying to bat away all of the statements during the legislative process that called functions of the trigger the single pull of the trigger by the shooter.
That's right.
But it's not classic legislative history. It's how people understood a term at the time. That's not legislative history.
Well, it's still legislative history. They're just using it for a purpose that they
Well,
claim.
Justice Thomas said in McDonald versus City of Chicago that it's perfectly acceptable to do that, to use, he said, if it's being cited to show what lawmakers, how lawmakers used a particular term that's different than what they intended.
So if we're using legislative history in an effort to discern the original public meaning of the statute, which is how I understand Your Honor's characterization, and I think that's how Mr. Fletcher is trying to characterize his reliance on this statement from Mr. Frederick, which
It's not just
the
that.
statement of a lobbyist.
We've got statements in the House. We've got from legislators in the House. We have statements from legislators in the Senate. All of them consistently translating function of the trigger to mean a single pull of the trigger.
Right, and they're all wrong because the statute also was written to encompass weapons that have push triggers rather than pull triggers. And the Solicitor General acknowledges this point in her opening brief. So
what it suggests to me is that, contrary to what you're saying, that is they never understood this to be how the trigger functions, but how the shooter functions.
no, I think we should draw the exact opposite inference. It proves how unreliable legislative history is as a tool to try to discern what
We're
a
gonna
statute means.
disagree.
Because, well, it's because, Justice Sotomayor, the phrase pull of the trigger can't be equated with function of the trigger. And even the Solicitor General acknowledges that because they say in their brief that the statute needs to be read in a way that encompasses fully automatic weapons that have push triggers rather than triggers that are pulled.
And you
so the
agree.
word function, I'm sorry, go ahead.
And you agree.
I agree that function
But
can't
the
be
only way
equated
you
with the
can
word
get
pull.
there is by looking at what the shooter is doing.
No, that's
Okay,
not correct.
Counsel,
You don't
thank
need to look at what the shooter's doing. A weapon can go off by accident. You don't need a shooter. There's still a function of the trigger. If the weapon falls onto the floor and goes off accidentally with a discharge, the trigger has functioned, even though the shooter hasn't pulled the trigger or pushed it or bumped it. What matters under this statute is what the trigger does. And all these examples that we see in the Solicitor General's brief, Justice Gorsuch mentioned this earlier, when they're taking transitive verbs, when they say swing of the bat, or stroke of the key, or roll of the dice. All of those are transitive verbs that are capable of taking an object. So when you see swing of the bat, there's obviously an unnamed actor in that sentence that is the subject of the verb swing. The bat can't swing itself. The bat's an inanimate object. Function of the trigger is entirely different. Function is an intransitive verb. It can't take an object grammatically. It's impossible. Trigger has to be the subject of function. It can't be the object. I'm sorry.
Justice
The FDA
Counsel, what do we do with the fact that these two people that you rely on, Francis and Scope, that Indiana and Texas have abolished abortions and abolished them by pills or otherwise? Now, we can get into whether other people are illegally breaking the law and supplying it contrary to law, but what does that do to your probability? Which is, it's already infinitesimally small because there are thousands of hospitals in the country, 50 states, I don't know how many territories, thousands and thousands of places where pregnant women go who may be suffering from miscarriages or otherwise, to know or to even imagine how one doctor is going to ever actually see a patient that it's going to be, that he or she is going to be forced to intervene on their behalf, but then add to it that this is illegal in these states.
So I think the best answer, Justice Sotomayor, is that past is prologue. In our declarations, we have 3 doctors who have treated harms from abortion drugs at least a dozen times. We have 2 examples when women went out of state. And if you go out of state, there's a higher likelihood you're not going to have a follow-up visit. What the FDA's regime has done is turn ER rooms into those follow-up visits. We've had that happen with both Dr. Jester, where a woman went to New Mexico and returned to Texas, as well as Dr. Johnson, where a woman went to Illinois and returned to Indiana. Indeed, according to Guttmacher, 1 in 5 abortions take place out of state in surge states like New Mexico, like Illinois, the border states in which our doctors reside.
The district court and the dissent below had a different variation on the statute and how to read it. You were starting to explain that to the chief. Could you do it if we accepted the district court's view? I presume that you could do it if we accepted the dissent below, correct?
Yes.
Yeah,
so
but your whole response to Justice Ketanji, to Justice Jackson, sorry, to Justice Jackson, is that it assumes the dissent's view.
I thought that Justice Jackson was potentially proposing even a broader view, including focusing on the availability part and making clear that when the whole point is to prevent the proceeding, including the consideration of evidence in the proceeding from happening, that could qualify. Okay. I think it becomes potentially harder on the Judge Katz's view and especially harder on the Judge Nichols' view, and that's precisely because Judge Nichols seemed to think that to prove obstruction, it had to be limited to taking action with respect to the documents themselves, and that would be a difficult standard for us to satisfy.
You read our discussion on corruptly yesterday. It's clear. You've endorsed the Robertson view. Could you tell me what you feel about the Walker view, Judge Walker being the part of the majority below? I assume you know that, but...
Yes. So Judge Walker articulated an idea that corruptly has to turn exclusively on the government being able to show that the defendant sought to secure an unlawful advantage for himself or someone else. We certainly agree that that's one way for the government to prove corrupt intent. It's a way that has traditionally been deployed in the tax context because the very theory of the case is that the defendant is violating the tax laws or taking efforts to secure an unlawful advantage under the tax laws. But I think that it would be incorrect for the court to suggest that that's the exclusive mechanism for the government to try to prove corruptly. You know, there are various other ways where we might have evidence of, as we think we do here, unlawful means committed with consciousness of wrongdoing, and there's no basis in the common law or in how the term corruptly has long been understood to limit the government's ability to prove it only with that one specific way that Judge Walker pointed to.
The draw in this case appears to be the fear that reading the government's view of either yesterday's case or today on its plain terms would make it so broad that somehow that presents a problem. I think the judges below struggled with that by saying that gets addressed in the word corruptly and in the nexus requirement, which is the point you made today. But neither of those 2 issues were resolved below because that wasn't the question below, correct?
That's right. The only issue that the D.C. Circuit resolved was the meaning of the actus reus.
And the only issue between us is whether we read the words, how we read these words.
That's right. But I don't want to lose sight of the fact, as your question touched on, that there are inherent constraints built into the other elements of the statute. The nexus constraint is a really critical one. It is the paradigmatic constraint the court has pointed to ensure that obstruction statutes don't sweep too broadly and scoop up everyday conduct that might be happening out in the world. It has to have that tight connection, the relationship in time, causation, or logic with the official proceeding. And of course, corruptly, we think, sets a very high bar, as evidenced by the fact, as I said to Justice Kagan, it's not like we can even prove it with respect to everyone who was in the riot at the Capitol on January 6th.
Ask you a question about the scope of your ordinance. So as Justice Kagan was pointing out, this criminalizes sleeping with a blanket at a minimum, right? Yeah. Correct. But as I understand it, after this decision and maybe after Martin, before that, there was some question about whether it also criminalized having fires, campfires, tents. Can you talk a little bit about that and what the scope of it is? Does the Constitution then make it impossible for a city to limit the use of fires and encampments, tents, those kinds of temporary shelters?
It really does, because the rationale of Martin, the argument that it's a biological necessity to sleep outside, the respondents argue a blanket is necessary in Oregon. Some might argue a tent and a fire is necessary in North Dakota. The Eighth Amendment really doesn't give us any answers to what cities can and can't prohibit. It's really administratively impossible for cities on the ground as well as for courts to administer. So we're seeing—
I'm sorry. We have nothing to do with fires or tents. That was exempted under the district court's injunction, and the circuit court didn't require that. We're talking only about sleeping with a blanket.
Well,
So let's narrow it to what it is. I agree there might be other cases in the Ninth Circuit that are not rational. And I don't mean to throw aspersions at those holdings, but some of them are not permitting time, place restrictions. Let's go beyond that. Let's go here. Here you're not precluded from prohibiting fires. You're not precluded from prohibiting tents. What's at issue is, are you prohibited from having someone wear a blanket anywhere in the city? Your intent was to remove, stated by your mayor, intent is to remove every homeless person and give them no public space to sit down with a blanket or lay down with a blanket and fall asleep.
that's not the intent of the law, and I would like to address that point, because the other side—
Why don't you answer the basic question?
Yes. So
It's not about fires. It's not about tents. It's about not being a time and place restriction, about eliminating all choices.
So we think that it is harmful for people to be living in public spaces, on streets and in parks, whatever bedding materials, when humans are living in those conditions. We think that that's not compassionate, and that
Oh,
there's
it's
no
not, but
dignity in that.
neither
don't.
is providing them with nothing
Well,
to alleviate that situation.
this is a difficult policy question, Justice Sotomayor. It is.
Where do
and
we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
So this is a necessity defense, as I mentioned, under Oregon law, is available. States are able to address these concerns. This is a complicated policy question. We believe that the Eighth Amendment analysis, to go back to it, focuses on the low-level
What's so
fines.
complicated about letting someone somewhere sleep with a blanket in the outside if they have nowhere to sleep? The laws against defecation, the laws against keeping things unsanitary around yourself, those have all been upheld. The only thing this injunction does is say you can't stop someone from sleeping in a public place without a blanket. I'm sorry, answer the following question, and these are hypotheticals that are true. Hold on one second, and you can tell me whether Idaho's exception, and we still go back to the point that even if Idaho law fully complies with the federal law, you have a pregnant woman who is early into her second trimester at 16 weeks, goes to the ER because she felt a gush of fluid leave her body. She was diagnosed with PPROM. The doctors believe that a medical intervention to terminate her pregnancy is needed to reduce the real medical possibility of experiencing sepsis and uncontrolled hemorrhage from the broken sac. This is a story of a real woman. She was discharged in Florida because the fetus still had fetal tones, and the hospital said she's not likely to die, but there are going to be serious medical complications. The doctors there refused to treat her because they couldn't say she would die. She was horrified, went home. The next day, she bled. She passed out, thankfully taken to the hospital. There, she received an abortion because she was about to die. What you are telling us, is that a case in which Idaho, the day before, would have said it's okay to have an abortion?
Under Idaho's life-saving exception, a doctor could in good faith, if the doctor could in good faith medical judgment determine...
No, I'm asking you. The Florida doctor said, I can't say she's going to die.
Yeah, and Your Honor, my point is...
If your doctor says, I can't with a medical certainty say she's going to die, but I do know she's going to bleed to death if we don't have an abortion, but she's not bleeding yet, so I'm not sure.
The doctor doesn't need to have medical certainty. The Idaho Supreme
Counsel,
Court
answer
answered that
yes
question.
or no. Cannot say that there's likely death. He can say there is likely to be a very serious medical condition, like a hysterectomy.
Based on the...
Let me go to another one. Imagine a patient who goes to the ER with pre-prom, 14 weeks. Again, abortion is accepted. She was in and out of the hospital up to 27 weeks. This particular patient, had to deliver her baby. The baby died. She had a hysterectomy, and she can no longer have children. All right? You're telling me the doctor there couldn't have done the abortion earlier?
Again, it goes back to whether a doctor can, in good faith medical judgment...
That's a lot for the doctor to risk.
Well, I think it's protective of doctor judgment, Your Honor.
When Idaho law changed to make the issue whether she's going to die or not, or whether she's going to have a serious medical condition, there's a big daylight by your standards, correct?
It is very case by case. The examples
That's
of
the
prom...
problem.
I'm kind of shocked, actually, because I thought your own expert had said below that these kinds of cases were covered. And you're now saying they're not?
No, I'm not saying that. That's just my point, Your Honor.
Counsel, the problem we're having right now is that you're sort of putting preemption on its head. The whole purpose of preemption is to say that if the state passes a law that violates federal law, the state law is no longer effective. So there is no state licensing law that would permit the state to say, don't treat diabetics with insulin. Treat them only with pills, metformin. And a doctor looks at a juvenile diabetic and says, without insulin, they're going to get seriously ill. And the likelihood, and I don't know what that means under Idaho law, we'll get to that shortly, because, I don't know, we believe this is a better treatment. Federal law would say, you can't do that. Medically accepted, objective medically accepted standards of care require the treatment of diabetics with insulin. The medically accepted obligation of doctors when they have women with certain conditions that may not result in death, but more than likely will result in very serious medical conditions, including blindness for some, for others the loss of organs, for some chronic blood strokes. Idaho is saying, unless the doctor can say in good faith that this person's death is likely, as opposed to serious illness, they can't perform the abortion. So I don't know your argument about state licensing law, because this is what this law does. It tells states your licensing laws can't take out objective medical conditions that could save a person from serious injury or death.
Yeah, I think there are two crucial responses to your point. Let me begin with the preemption point. Subdivision F and Section 1395 actually are telling HHS, the federal government, and courts just the opposite, that you
No,
don't...
it's saying you can't preempt unless there's a direct conflict. If objective medical care requires you to treat women who present the potential of serious medical complications, and the abortion is the only thing that can prevent that, you have to do it.
No.
Idaho law says the doctor has to determine not that there's merely a serious medical condition, but that the person will die.
Yeah.
That's a huge difference, counsel.
Your Honor, we agree that there is daylight between how the administration is reading EMTALA and what Idaho's Defensive Life Act permits. We agree that there is a controversy here, but what I'm saying is that...
No. There's more than a controversy. Because what you're saying to us is if EMTALA doesn't have preemptive force, then not just Idaho, it has a saving condition for abortions when it threatens a woman's life. But what you're saying is that no state in the nation, and there are some right now, that don't even have that as an exception to their anti-abortion laws. What you are saying is that there is no federal law on the book that prohibits any state from saying, even if a woman will die, you can't perform an abortion.
Your Honor, I know of no state that does not include a life-saving exception. But secondly,
some have been debating it at least. And if I find one, but your theory of this case leads to that conclusion.
I think our point is that EMTALA doesn't address that very...
Could I hear your answer?
Yeah. In the administration's reliance on a standard like best clinical evidence or some national norm, I think that's very fraught because what it really is saying is the text itself doesn't address what stabilizing treatment is required. You go outside the text to professional standards that are floating out there that might change day to day, and that really boils down to a question between a conflict between what ACOG says and what Idaho law says, and that's not a...
Thank you, Counsel.